Welcome to this episode of Term Talk, a video podcast that analyzes recent Supreme Court opinions important to lower courts. I'm Beth Wiggins, Director of the Research Division at the Federal Judicial Center. In this episode, we discuss recent opinions related to the right to free speech. In both Free Speech Coalition versus Paxton and TikTok versus Garland, the court applies intermediate scrutiny to speech determined to be content neutral. To discuss these opinions, I'm pleased to welcome Paul Clement, former U.S. Solicitor General and founder of Clement and Murphy, PLLC, and Erwin Chemerinsky, Dean and Jesse H. Chopper, Distinguished Professor at University of California, Berkeley Law School. Thank you for your time today. So Paul, to get us started, will you define the levels of scrutiny applied in speech cases and then take us through the facts of Free Speech Coalition versus Paxton?
So I'd be delighted to, Beth. As I think most people are aware, the Supreme Court has long used three levels of scrutiny to approach most free speech cases. And the levels of scrutiny, I think, are perceived by many to be outcome determinative in most of these cases. So the highest level, most demanding level of scrutiny is, of course, strict scrutiny, which has often been referred to as strict in theory, but fatal in fact. That requires the government to justify a content-based restriction on speech or a viewpoint discriminatory restriction on speech to first point to a compelling government interest and then show that the regulation is narrowly tailored to achieve that compelling government interest. And one way to capture how tight the narrow tailoring has to be is one of the government's burdens is to show that the way they're addressing the problem is the so-called least restrictive alternative, the most speech-friendly alternative for addressing the issue. So that's strict scrutiny, and you can see why, given the least restrictive alternative test, it's often considered to be fatal in fact. There are a few Supreme Court decisions that have upheld the law, even applying strict scrutiny. So then I'll jump to the lowest level of scrutiny, which is rational basis review. And that's familiar to, I think, most people because it's the general default level of constitutional review that applies to economic legislation and in other contexts where we don't have quote unquote heightened scrutiny. And under that, the test is quite forgiving of the government. And I think it's probably fair to say that the government simply needs to point to a rational basis for the law. There's none of this tailoring requirement. And in practice, the rational basis test means that the government almost always wins when it tries to defend the restriction on speech. Again, you could point to a couple of cases over the years where a court has applied what sometimes affectionately referred to as sort of rational basis with teeth and struck down a law, but for the most part, rational basis means that the government wins. And then in between, there's intermediate scrutiny. And in intermediate scrutiny, the government no longer has to point to a compelling government interest. It's enough if they can point to an important government interest that's not directly related to the suppression of speech. And then at that point, they have to show that the law substantially furthers that important interest, but without the burden of showing that it's the least restrictive alternative. So in a sense, that those three levels of scrutiny set up very nicely the path that this case took to the Supreme Court of the United States. The Texas passed what is affectionately referred to as HB 1181. It's a shame they didn't have a catchier title, but that's what we were wrestling with. And what that law did is it essentially required individuals to essentially show that they were adults in order to get to material that is obscene as to minors, but not obscene as to adults. And the specific way that the law accomplished that is it regulated those websites that had commercial websites that had at least a third of their content that was classified as obscene as to minors. And those websites would have to essentially have a mechanism for age verification in order to operate lawfully in the state of Texas. The reason this case sets up so nicely these kind of different levels of scrutiny is in the first instance, you had the district court that looked at this law and applied strict scrutiny. and not surprisingly, applying strict scrutiny, then preliminarily enjoined the law from going into effect. The appeal of that preliminary injunction then went to the Fifth Circuit. The Fifth Circuit then decided that the right level of analysis was not strict scrutiny, but the other end of the spectrum. They applied rational basis, and not surprisingly, the Fifth Circuit upheld the law, or at least allowed it to go into effect and reverse the preliminary injunction. The issue comes to the Supreme Court then, principally focused on the level of scrutiny, though the court went on essentially to decide the case a little more broadly. And the Supreme Court ultimately decides 6-3 that they will reverse the entry of the preliminary injunction. They will essentially affirm the result of the Fifth Circuit, but they'll do it by applying intermediate scrutiny rather than either of the levels of scrutiny applied by the lower courts.
So Erwin, can you tell us a little bit about how the court got there? What was their analysis?
Paul does a great job of explaining the levels of scrutiny. In the area of the First Amendment, though, the Supreme Court has said there are some categories of speech that are unprotected. So the government has great latitude to be able to prohibit and punish the speech. Incitement of illegal activity would be an example of that. Obscenity is another example of that. The Supreme Court has said since the mid-1950s that obscenity is unprotected by the First Amendment. In 1973, in Miller versus California, the Supreme Court articulated a test for obscenity. But it's interesting here that neither Texas in defending the law nor the Supreme Court in upholding it focused on this being speech that meets the test for obscenity. As Paul said, the Supreme Court instead focused on this being a category of speech obscene for minors and says, based on this category, intermediate scrutiny is the appropriate test. It's important to note that prior Supreme Court cases about age verification for sexually explicit material were inconsistent. There was a Supreme Court case in 1968, Ginsburg versus New York. It involved New York law that said that those under 18 could not buy sexually explicit magazines, and the Supreme Court upheld the law. On the other hand, in 2004, in Ashcroft versus ACLU, the Supreme Court declared unconstitutional the Child Online Protection Act that required age verification for websites with sexually explicit material. The Supreme Court here, in Justice Thomas' opinion, stresses that this law is content neutral, except for it being the category of obscene for minors. Justice Thomas' opinion stresses the traditional power that the government has to protect minors, the strength of the government's interest in safeguarding minors from exposure to sexual material is core to the opinion. He says that there's only an incidental burden on adults. This isn't keeping adults from having access to the speech. It's just requiring age verification. And I think it's important to the majority's opinion that it stresses that age verification is something that the government does in many areas, for buying alcohol, for lottery tickets, for fireworks, for getting a driver's license. And so the court says, we could require this for a brick and mortar store. There's no reason the government can't require age verification for sexual websites for minors.
Paul, can you explain why the dissent thought strict scrutiny should apply rather than the intermediate?
One of the things that's a bit of a puzzle in the Supreme Court case law is that, as a general matter, what gets you into strict scrutiny and is pretty close to the sort of, the cardinal sin of government regulation of speech is if the regulation of speech is content-based. But the Supreme Court, at the same time, as Erwin says, has always treated obscenity as unprotected speech. When the state, in this case, Texas, decides to target a class of speech, but not say that it's obscene as to minors and adults, which at least might get them out of the levels of scrutiny debate and into kind of a modern case trying to figure out exactly what obscenity is and what the metes and bounds of the obscenity test would be, which is a notoriously difficult enterprise. Texas instead sort of comes up with this idea that they're regulating material that is obscene as to minors. And I think the thrust of the dissenting opinion is, if we're going to understand that as something other than like a new category of unprotected speech, and nobody's making that argument because they're not trying to block access to this material for adults, then it's really kind of impossible to understand this differential treatment of material that is obscene as to minors as anything other than a content-based restriction of speech. And therefore, it would trigger and should trigger, in the dissenting justice's view, strict scrutiny. And Justice Kagan, in this opinion, also draws on the prior precedents of the Supreme Court, which Erwin alluded to. I think he's absolutely right to say the court's prior precedents were inconsistent. You have the sort of Ginsburg decision from back in the day dealing with kind of bricks and mortar stores. But in more recent cases where Congress was trying to regulate sort of materials on the internet, the court had always approached those restrictions as something that triggered strict scrutiny. And so I think the dissenters were saying some combination of what the state's trying to regulate really is defined by the content of the speech, and those prior precedents meant that the court should have applied strict scrutiny in this case. I would only add that I think it's noteworthy that the dissenting opinion, sometimes in these free speech cases, the dissenting opinion essentially is pretty unsympathetic to the government in the sense that they really view the government as engaged in a censorship activity that really is not something that's consistent with our First Amendment traditions. I would describe the dissenting opinion here as much more sympathetic to what Texas was trying to accomplish and really focused on the critical difference between strict scrutiny and intermediate scrutiny is, of course, as we were discussing, whether the government has to show that the approach that they're taking is the least restrictive alternative. And I think in the dissenters' view, they actually were open to the idea that this law might be the least restrictive means to do age verification for these kind of sites, and that might be constitutionally permissible if it is indeed the least restrictive alternative. But they primarily were critical of the majority opinion as essentially letting the state off the hook and not having to show that the way they were approaching it here was the least restrictive alternative.
These issues are likely to come up again, and so I guess I'll just stay with you for a minute. What do you think the takeaways from this opinion are for the lower courts?
So I think the takeaways from the lower courts are a couple of things. I mean, one is they now are going to have to wrestle with this sort of new category of speech, obscene as to minors. And I don't think that will be an easy task. And, as I was alluding to, I think sort of applying the Miller test has been something that's kind of so notoriously difficult. The Supreme Court has really shied away from having to try to do it much in recent years. But now the sort of lower courts are going to have to wrestle with this sort of obscene as to minors category. And then, of course, the other thing that the lower courts are going to have to wrestle with is the idea that, okay, age verification is, a number of states are experimenting with age verification in a number of contexts, and they're trying to do it with respect to, say, access to social media sites and the like. And I don't think that the states in those cases are going to be able to say, well, all of this material is obscene as to minors. I mean, the Texas law here was really limited to sites that had over a third of their material that would trigger that category. And so when the state is trying to vindicate sort of other interests by requiring age verification, I think those are issues that the lower courts are going to have to struggle with. The last thing I would say, just before I'm very interested to hear what Erwin has to say about the same topic. But the one other thing I would say is, in some ways, this is a case where I wonder whether the court wasn't a little bit sort of a prisoner of these levels of scrutiny. And there are other areas where the court has decided to address free speech issues in a little bit more of a sui generis way and adopted a test that doesn't map on to the level of scrutiny. So you think of things like the Pickering test for government employees. And I suppose you could describe some of those things as a species of intermediate scrutiny, but they're a little more sort of context specific. And I think there might have been room here for the court to almost say, look, when it comes to materials like this, like age verification is the way that we've approved in the past for governments to go after this. There's really no other way for the government to do this, which is to say, we don't have to sort of say there's now a category of speech that's sort of subject to intermediate scrutiny. We can just sort of say that the age verification as the mechanism for addressing this area of the law is a little more the sui generis permissible answer. If they'd done that, I think it might have left a few less loose ends for the lower courts.
So, Erwin?
I very much agree with everything Paul said. Let me just highlight two things. One is I think this case reaffirms the importance of the levels of scrutiny. A few years ago, in a Second Amendment case that Paul argued and won, the Supreme Court said it wasn't going to use the levels of scrutiny for Second Amendment analysis. And there's some speculation that maybe that would spread to other areas and the court would back away from the levels of scrutiny. This case shows the continued importance of the levels of scrutiny. If it's strict scrutiny, as Justice Kagan says, then the government has to use the least restrictive alternative. And this law, well, it may have been unconstitutional. But under intermediate scrutiny, the government doesn't have to use the least restrictive alternative, and the majority is able to find that that was met. So I think that the levels of scrutiny in First Amendment analysis and likely other areas are going to continue to be very significant. The second thing I'd point to is what's this going to mean for other government regulation of social media? Several states, Louisiana, Mississippi, Arkansas, have adopted age verification for minors having any access to social media. Recently, a federal court struck down the Louisiana law. The Supreme Court last summer refused to stay the Mississippi law, but Justice Kavanaugh wrote an opinion saying it's likely unconstitutional. On December 10th, a law went into effect in Australia that prohibits those under 16 from being on social media at all. And there's talk about whether states or even Congress should copy that in the United States. And when that's litigated, I think Free Speech versus Coalition versus Paxton is going to be very important in the discussion.
Thanks, Erwin. Let's move now to another case, TikTok versus Garland. The case arose on the emergency docket, but was decided after argument. Can you take us through the issues this case raised, Erwin?
TikTok is owned by a Chinese company, ByteDance. In the spring of 2024, Congress overwhelmingly passed, and it was bipartisan, a bill that said that TikTok could no longer operate in the United States after January 19th, 2025, unless it was sold to a non-Chinese company. Congress had a couple of concerns. One is if TikTok is owned by a Chinese company, China can learn information about who in the United States is viewing what. And second, there was concern that China could use TikTok to influence attitudes in the United States. President Biden signed the bill into law. It's important here to keep in mind there are 173 million people in the United States who use TikTok. This is prohibiting a major platform for communication. So those who use and post on TikTok brought a challenge arguing that it violates the First Amendment.
The court determined that the divestiture requirements were content neutral and applied intermediate scrutiny. So, Paul, what did the court decide and what's the scope of the decision?
Sure. So the court decided, as you suggested, that ultimately it was going to analyze this under intermediate scrutiny. But it did something quite unusual, which is it first addressed the arguments that had been made that this really didn't trigger the First Amendment at all, or at least only triggered rational basis review. And the argument there was not a frivolous one. On the one hand, as Erwin says, it's hard to imagine a law that had a bigger impact, at least in its very short window in which it had any impact. But there's hard to imagine a law that had more of an impact on sort of a communication medium, more of an impact on the way that many people communicate in very expressive ways. So in some respects, the First Amendment impacts of the law were obvious. But in other ways, this really was a law that I think is fairly described as content neutral in the sense that it was really focused on ownership of the communication assets and not the communications or the content of the communications. You could have the exact same communications on TikTok from the beginning to the end. Everything on there could be the same, and if it had American ownership, it was going to comply with the congressional statute and the content would continue. Whereas if there was foreign ownership, that would be prohibited by the law. So in that sense, there was a reasonable argument that it was, content neutral and really didn't implicate the First Amendment at all. What the court did is assume, without deciding definitively, that it did trigger the First Amendment. And then the court said, assuming it applies, the First Amendment is triggered at all, it triggers only intermediate scrutiny. And then as to intermediate scrutiny, the court focused on the interests that Congress had identified, which were, in the court's view, security related, national security related, and not focused on speech itself. And then the court, again, as we discussed a minute ago, once you're in intermediate scrutiny, you don't have to address whether this approach is the least restrictive alternative. An ownership ban is sufficiently draconian that it would probably be hard to argue that it was the least restrictive alternative. But the court said, nonetheless, since we're applying intermediate scrutiny, we're in a national security context where Congress has pointed to national security concerns. We're going to apply a fairly forgiving version of intermediate scrutiny. The last thing I'll say is I think both in the way the court approached the First Amendment question, this sort of odd construct of saying, we'll assume the First Amendment applies, even though we acknowledge there's a reasonable argument it doesn't. And then the adoption of a pretty deferential form of intermediate scrutiny and focusing on this challenge being as applied, focusing on the decision being narrow. I think all of that reflected the incredibly unusual posture that the court was addressing these issues. You alluded to this as being a case that started on the emergency docket, but was nonetheless argued and then decided with an opinion of the court. The opinion of the court was a per curiam opinion. And at the same time, the opinion issued 7 days after argument. So I think the court was conscious that it was moving very, very quickly here and didn't want to sort of lay down markers that were too permanent, given the sort of expeditious way they had to handle this case.
So what question or questions did the opinion leave open?
So I think the opinion left open a lot of questions. And I think, again, that's sort of consistent with the way that the court handled this case. And in terms of thinking about kind of the how this case fits with the kind of the court's approach to other issues, I think for the most part, this case, in my view, Erwin may have a different view, but this case is very kind of sui generis. I think that, this was a very kind of dramatic and bipartisan effort by Congress. And I think in a number of contexts, the Supreme Court has been a little bit frustrated by Congress's inactivity. And I think for Congress to have weighed in on a national security issue in this kind of bipartisan way, it would have put a lot of pressure on the court if they would have said, all right, Congress finally did something, but what they did is unconstitutional. So I think the court was really trying to write pretty narrowly here. To me, the one thing I think is interesting in terms of going forward is I did allude to the fact that this law really only went into effect for about 36 hours and has been effectively suspended by the executive branch ever since. And I wonder in the long run how the Supreme Court will process that, because the Supreme Court certainly handled this case as if it was an emergency. The law was scheduled to take effect on January 19th. As I mentioned, the court really scrambled to issue its decision and allow the court, the act of Congress, to go into effect with the imprimatur of the court by issuing its decision on January 17th, a couple of days before the law was supposed to go into effect. But having been told by Congress, at least, that this really was an emergency and it needed to go into effect and the court needed to move heaven and earth to get the opinion decided before January 19th, the fact that the law really hasn't had any real world effect and the emergency seems to be, at least in the executive branch's view, somewhat overstated, I think is something that I don't know that the court will completely forget that dynamic.
Erwin, what are your takeaways from this case?
Again, I so agree with what Paul said. Let me just add two things. First, this is a case that shows great deference by the Supreme Court when the federal government claims national security interests. This is part of a long-term pattern in the Supreme Court of giving deference to the government when it assumes and asserts national security. As Paul said, this was, and I think your words were, a very deferential form of intermediate scrutiny. It's interesting that the court, in its opinion, accepted only one of the two justifications proffered by the United States. It said that if TikTok is owned by a Chinese company, then China will be able to learn information about users in the United States. And as I read that, I wondered, how will it harm national security for China to know what dance videos people are watching over TikTok? The government doesn't explain that in its brief. The Supreme Court doesn't explain it. And this is the deference of the government claims national security, and the court's willing to accept that. The second point I was going to make is exactly what Paul was talking about with regard to the practical significance of the case. In fact, I don't think we've ever seen anything like this. A bill gets passed overwhelmingly by Congress, the president signs it, the Supreme Court unanimously upholds it, and then the government says, never mind, we're not going to pay any attention. The law has a provision that said that the president could extend it going into effect for 90 days if there's a showing of a substantial progress towards a sale. President Trump, on taking office, did not invoke that provision. He initially said the law just won't go into effect for 75 days, and he kept extending that. And the law has, to this point, never gone into effect. Can't think of another situation like this. And I very much like Paul's point of how is the Supreme Court going to react to this, and what might it mean for future cases?
Thank you both for joining us today for this great discussion, and hope to see you again soon.